Welcome to EU Privacy for All, Session 13, Article 9, Special Categories of Data. European Parliament added several situations in which sensitive data, that is to say special categories of data, would be identified. Some of them were retained, such as biometric data. Others were not, such as gender identity or administrative sanctions, judgments, criminal or suspected offences, convictions or related security measures. Those are framed in a different provision, Article 9a. They also provided two additional derogations, the entering into a contract or archive services. It was not retained. EU Council added a fifth paragraph. Member States may maintain or introduce more specific provisions with regards to genetic data or health data. It will be retained and broadened. In GDPR, Article 9 on processing of special categories of personal data looks like Article 8 in Directive on processing of sensitive data. However, in paragraph 1, additional categories of data are added as being special categories, such as genetic data, biometric data, and sexual orientation. Paragraph 2, specifying cases in which the prohibition to process special categories of data shall not apply, some modifications were operated. For instance, regarding the processing of data related to employment, the provision was broadened, including now social security and social protection law. Others provision look like a lot what was already laid down in the directive. In the following provisions of Article 9, public interest is set forth. Generally speaking, or regarding preventive or occupational medicine, public interest in the area of public health, or achieving purposes, scientific, historical, or statistical purposes. As proposed by EU Council, a provision was added in the end of the article. Member States may maintain or introduce further conditions, including limitations with regard to the processing of genetic data, biometric data, or health data, meaning that national provisions could restrict, furthermore, the processing of such data. The key recital in GDPR, a really long one, recital 41. Let's stress three key points from this article. First, by their nature, particularly sensitive in relation to fundamental rights and freedoms, those data deserve specific protection. Second, the processing of photographs is given as an example, just to mention that it is not systematically to be qualified as sensitive processing. They will only be covered by the definition of biometric data when being processed through a specific technical means allowing the unique identification or authentication of an individual. Finally, Member States may lay down specific provisions on data protection regarding public interest. Other provisions in the GDPR frame the processing of special categories of data. For instance, for public health purposes. In such a case, suitable and specific measures should be adopted. when automated decision-making and profiling is supposed to be implemented. Then, specific conditions should be put in place. Whenever a controller or a processor not established in the Union is processing special categories of data, it should designate a representative. Finally, a data protection impact assessment is mandatory whenever taking decisions regarding specific individuals is based on the processing of special categories of personal data. In the directive, the provisions were almost the same as in GDPR. As already stressed, some categories of data were not mentioned, such as biometric data or sexual orientation. What should accountable data controllers get prepared for? Keep on implementing the core obligations deriving from Article 8 of the directive, but adding 3 special categories of data: genetic data, biometric data in order to uniquely identify a person, and sexual orientation. Regarding derogations, knowing that the one based on employment laws will be broadened to social security and social protection law. Anticipating that member states may maintain or introduce further conditions with regard to the processing of genetic data, biometric data, or health data. Being ready to demonstrate compliance, which concretely means adopting suitable and specific measures overall, carrying out DPIAs, and adding specific additional measures in case of automated decision-making. Finally, if not based in EU, nominating an EU representative. What will be interesting is knowing how member states and the European Data Protection Board, or national DPAs, will interpret the provisions, and most of all, derogations.